Morning, Howard.
Trying to get everybody in, so hang in there, guys.
Hi, Howard.
Yes.
Where is the? Do I actually have to lock on myself?
Sorry, what do you mean?
Oh,
You're
do
in
I have
already.
to punch in my V number to let you know?
Yeah, later on. Yeah, yes, you guys should put it in. I'll let everybody know around 11 o'clock what to do, because we have quite a few office joining us. So I think for people that's joining in from the other office, I'll let them know what to do. Is you should put in your first name, last name, your V number, and which office you're from. That way we can track everybody.
Okay, even with the office. Okay.
I think just put Killarney and Killarney, Broadway. We have Broadway, Abbotsford, Kerrisdale, who else? Canby. We have 5 to 6 office joining us today. We will have a big group today.
All right.
我这老小子是给我运气的，他妈什么事儿没有，肯定不戴口罩，是吧？对，在目。
You're muted also.
Hey, Howard, you there?
Yes.
Okay. Okay, good.
So who am I speaking to?
It's Herb. We had a screw up on the
Oh.
deposit, so I'm
Okay.
driving, so
Oh, I
I'll
see.
be doing it. I'll be doing it from the iPhone here. Okay.
Okay, no worry. Okay, thanks, sir.
Good morning, Howard.
Hi, Evan.
Hey, good morning.
Good morning. So bear with us in a few minutes. I think we might have, well, we've got about 5 office joining us today.
Hi. Oh my goodness.
Yes, I think you might have 200 to 300 people. Our maximum capacity is 300. Let's break that record.
Is there you get
I'm
up for Zoom.
I'm controlling the people coming in, so that's why I'm working on it at this point. Just hang in there, and I'll introduce you a little bit later.
Yeah, no worries. I'm just trying to. This is only the 3rd time I've been on Zoom, so I'm just figuring this out too. So.
Okay. I'll work the slide, so don't worry. I'm here with you.
Yeah, that's great. Yeah, your HQ, your quarterback, your QB on HQ.
No problem, man. Don't put me on the sidelines.
Yeah.
I'm going all the way.
Yeah.
Anyways, for the people that has joined, thank you for joining right now. Right now it's 10:54. I think we'll start around 11:05 to wait for everybody to come in. I think today we might have 5 to 6 office joining us today for the Zoom seminar. While you guys are waiting, maybe if you guys can sign in, I need your first name, your last name, your V number, and which office you're from. Then we can track who has joined the meeting. If you guys can do that in the chat, just type in your first name, last name, your V number, and which office you're from.
Howard,
Yes.
just letting you know, I'm actually on the road. Could you help me sign in?
Text it to me later on then. Okay, I got you. Yeah.
Okay.
Yeah, I got you. Yeah.
Just that I don't know how to type it while it's on mobile. So.
Okay, no problem. I know some of them are mobile. It'll be hard to type in. Then maybe whoever's on mobile, maybe you can text your name and V number to your managers. That way they can track who's here as well.
All right. Thank you.
getting really good.
我还要吃五根肠。台湾比五根肠饭好吃的东西多了。
哎，我要怎么看我吃？我要怎么？
抓煎。哎，你们有没有在做炸生蚝？我最喜欢吃的就是炸生蚝。
是。
炸生蚝好吃呀。你们那里有吗？我们那里不炸。对啊。我们那里吃做汤或者吃生的。我们都有，但是我。怎么听不到？那有的那本身就有喇叭。不可以了。
So I put something on my screen here. It's the business code of Mr. Ivan C. He's the lawyer that's going to be doing this presentation. I just want to put his contact information. If anybody wants that contact information, we have it here.
Morning, Howard.
Good morning. Hey, Arnold.
Since we're not having lunch today, I figured I'd put a good backdrop picture in.
Okay, thank you. That makes everybody hungry. Okay, anyways, 11:06 right now. Good morning again, everyone. Thanks for joining the Zoom meeting this morning. Before we start, let's do some house cleaning. I have muted everyone on the Zoom meeting. The reason is we don't want to interrupt the speaker while he's going through the presentation. At the same time, when you guys have time, please type in your first name, your last name, your B number, and which office you're with. This way we can track who has, I guess, attended the Zoom meeting. As well, whoever is on an iPhone that cannot type, they may want to text their manager that they have joined the meeting with the me number. This way they also can track as well. And at the same time, if you want to have any question asked for our speaker, please type it into the chat function on the bottom there. So this way I'll monitor that and we can ask a question accordingly. I think here Q&A at the end of the presentation. We have lots to cover today for the presentation. You know, he'll be covering a lot of different angles regarding COVID-19 and some of the problems that we have with contract. You know, so let's before I start, I want to introduce Mr. Ivan C. from Ivan C. Law Corporation for taking the time to come and do a presentation to all of us. He's been in business for quite a while, and we've done a lot of business with him. He has also joined my office for quite a few functions, and he's very knowledgeable. And what he have done for us as Sutton Group West Coast Realty, as well as he have extended his. If anybody wants to be a PREC, he had a special one right now for all the realtor that wants to be a PREC. It's $1,300 for his fees for doing that for you to set that up. I have the detail later on to give it to you guys. I'll send it to your managers if you want to send it out to you guys. You guys can have that, and he's giving us a special for all the realtor that want to turn to PREC as we go forward. At the same time, I'm sensing for the last 2 weeks, the market has really picked up, compared to what's happening in April. The first 8 days of May has the numbers of sales that's coming in, to Sutton, it's not bad. It's much better than what we had in April, but May, it's looking good. So, I mean, my kudos to all of you. Let's get back out there. And I think there's a lot of seller and buyer who needs our help. So, go back out there. There's a lot of business out there. Okay, but at the same time, you got to stay safe. Social distancing is another way. You got to be safe and follow the rules. So I'm going to turn over the mic over to Ivan.
Tuning in today. I know it's a beautiful day out. I'm glad you're all in here. As long as we're inside, we're all safe, and we can tune in. And thank you for coming in and checking in to Zoom. I just wanted to introduce a little bit about myself more. I've been in real estate law practicing for about 23 years. I do litigation as well. I do residential, I do commercial. So some of the topics that are covered throughout here are things that are actually happening in real time, things that are issues that I'm dealing with and working through that is affecting a lot of my clients that are buying or selling, and agents that are calling me for advice about how to deal with a certain situation. Maybe, Howard, you can show the first slide. I just want to have, there's a PowerPoint that I prepared, maybe as a PDF that Howard would put on that you can see. I'm not sure how the technology works. Tell me, Howard, if everybody sees the slide. I'm not sure what I see. This is new to me too, guys. So
yes, everybody's got the slide. So let me know which slide. If you want to move to the next one, I can move to the next one.
The next one would be great. I just want to, the next slide, and it's just a sample of some of the types of issues, sampling that's been happening in the last little while, in the last 2 months in particular. So you get the next slide, Howard? Not sure if it's,
sorry.
Yeah. While he's getting the slide up, I'll talk about it. In terms of financing, I have clients who are buyers who had their financing collapse because they were approved, but because of the loss of their income and their jobs, they were not able to get financing. And then they're in a precarious position because all subjects have been removed. And then I have clients as well who, seller clients who, before this, the ban on evictions had happened, had promised and on their contract had promised a vacant possession to the buyers. And then during this period of time, the tenants are not moving out. So that's an issue. And other issues have dealt with capacity and incapacity in terms of signing. Clients who have come back from quarantine, they are not able to come out and see a realtor or notary, or a lawyer. In some situations, no lawyers are as willing to actually meet that client either, and didn't know how to sign the person up. So then there's quarantines and lockdowns. I have overseas clients in China who, during the beginning of the lockdown, wasn't able to travel to see a Canadian or BC lawyer in Shanghai or Beijing or Guangzhou. So all these kinds of things in the last 2 months, I've actually had to work through and try to wing things out and help with a lot of clients. The commercial real estate issues, that's the next slide.
Yeah, I'm I'm on the next slide on commercial real estate issue now.
Okay, awesome. Yeah. So even commercial has all those similar deals. Issues. On top of that, though, compared to the residential, there is no commercial tribunal to deal with leases. Many clients who have tenants who are refusing to pay the rent, unable to pay the rent for the month, and then there have to be a lot of negotiations between the landlord and the tenants dealing with that. Some of the issues that have come up is looking at insurance issues and how it may help and buffer the blow when it comes to all of the losses that are happening. And then enforcement issues. You have a possession order of possession, but you can't enforce it. You want to deal with the person like a tenant if you have a landlord client who's not paying their the rent, but you can't enforce anything because the courts are closed. So these are extra problems with commercial real estate that is unable to be, that is on top of any residential real estate issues. The RTA, the Residential Tenancy Board, is still in operation. The hearings are still being held because traditionally they've always been held by teleconference and video conference anyway, so it's not affected by the closures in the courts. So underlying all of these issues, though, regardless of what situation you find yourself in, or a couple of questions. So we can go to the next slide, Howard.
Yeah, I've got the next, the big question one, yes.
Yeah, exactly. So to what extent can the reasons, any of those reasons about caused directly or indirectly by COVID, be a reason for releasing the parties from their obligations in a real estate related contract, whether this be a lease, whether this be a purchase agreement, residential or commercial? And then what happens if the transaction or real estate contract collapses as a result of the breach of the real estate related contract due to COVID-19? So regardless, one of those issues that come up and the deal can't complete, or a buyer or seller cannot complete. So this brings us to the next slide, Howard. Now, there are a couple of concepts I want to introduce you. You may have seen these around. They're very common in terms of what you hear. You might see a lot of posts and discussions and seminars about these ideas. So there's words and concepts and legal concepts such as frustration of contract. Another term that may be heard in more different circles is specific performance. Another one is the idea, the notion of a duty to mitigate losses. And then the other idea of force majeure clauses. So during this presentation, I'll go through some of these terms.
Ivan,
yep.
Ivan, sorry to interrupt you. Howard, the slides aren't changing over. Everyone's stuck on the first slide.
Oh, my goodness.
Sorry.
No, thank you. It's hard for me to know what everybody else sees either. So I think this Zoom thing is it's a new way of doing things, but there's also a lot of new things to learn every day. And maybe on the chats, people, if they can post a note to say whether they see the slides. Yeah, that is happening. I see the notes on the chats. And tell me if I guess someone posts on the chat if they see if they see everything now, if they see the slides. Oh, thank you. They see me. That's good. Yeah. So.
Is this great? Can you guys see this now?
Yeah, maybe because you got them all muted, you can check the chat. So.
Okay, I think
Yeah, it's okay now, Howard.
Okay, thank you. Sorry, guys. Hey, technology here. I mean,
no worries.
I'm fired.
Yeah. Good.
Yeah. So the next slide, Howard. There it is. Perfect. I see what it is. So the concept of frustration of contract. These are things I want to talk about in the upcoming slides and presentations. Specific performance, duty to mitigate losses, and force majeure. So the first thing, frustration of contract. You might have heard this. Whether or not this unforeseen event could cause people to say, hey, you know, it's beyond my control. I don't have to fulfill or follow through with my contractual obligations.
Hello.
So the next slide, Howard.
Okay, one more thing before I go move on to the next slide. I'll be sending this package to all the managers and they can send it out to the realtor. So you guys will have all the slides later on. So, I mean, you guys will have a copy of it.
Thank you, Howard. Yeah, so one of the things that I like to do is just to do a definition of, you hear the word, is it able to be used? So this is what I want to say. Where an event that is not reasonably foreseen and not self-induced, that significantly changes the rights and obligations in the contract, so that if the contract were to be enforced, the result would be radically different than what was bargained for, impossible, or illegal. And then you can say that the contract can be frustrated, meaning that the contract is terminated. The event has to be not temporary in nature and not simply something that makes the contract to be done to be more expensive or less convenient, but strikes to the root of the contract. Some of the important points that in this definition, so that you can understand, these are all important parts. The next slide, Howard. And tell me if the slide is up yet.
It's up, it's okay, yep.
Okay, perfect. I can't tell, but anyway, so the important points is a pandemic in the times of COVID. First of all, the first point is unlikely to be permanent. It may or may not be, but as you notice, and some of the restrictions now are starting to be lessened, this is probably not permanent. And then the next concept is, if the contract were to be enforced during a pandemic, the result will not be radically different than if it was not a pandemic. So it may make the transaction more expensive and less convenient, but not impossible. In that way, most real estate related contracts are not frustrated as a result of COVID-19 because of those different terms. The next slide, I want to show you an example of a situation that's come up. A buyer cannot buy a property because of financing issues, or buyer passes away, or the seller cannot provide vacant possession because the tenant won't leave, or if the buyer or seller is under quarantine. But if the reluctant party, whatever that situation is, was somehow made to compel them to complete the contract, the end result is what is the end result is what was bargained for, either the sale or purchase of the property. So in that sense, you can see that a lot of the real estate related contracts cannot be, the doctrine of frustration of contract would not be applicable, cannot be used to relieve all the parties from their obligations. Now, the next slide shows you a couple of cases which actually dealt with frustration in different contexts or related to real estate. The first one dealt with the seller unable to give vacant possession. There was other reasons as well, but one of them was the seller was trying to move to another house and using financing for another house. But the end result was they couldn't give vacant possession, but they couldn't use that idea that it was out of their control, that the tenant wouldn't leave, as a reason to be able to be released from the contract. So the liability still continues. The next client, the next case dealt with the foreign owner's tax. You know, a couple of years back, that was a big shock for a lot of foreign buyers. All of a sudden, they had like a huge increase in their purchase price. They didn't plan it. The government announced it, but it's an expense. In the judgment, it indicated it's just more expensive, but it's not a frustration of the contract. The last case that I put on there, in case anybody wants a link as well later, you can email to me, is the financing falling through with the buyer, and the buyer still had to be compelled or had to face the consequences, even because of whatever reasons the financing didn't come through and subjects were removed. So, and then one example that I did want to show you, and next slide, it's a case where actually frustration of contract was successful. And the reason for that is it was an unforeseen event, which is a zoning change that nobody could have predicted or seen coming. They announced it, and it changed the floor space ratio or development from 3.22 to 0.3, substantial. If you're planning on a development, this is a huge blow to whatever plans you're having as a developer. And then as for the seller, the kind of price that you were expecting for that. So it completely and radically changed the whole nature, because if they enforced the sale, what you have is the property that you can't do practically what you planned with it. In that situation, it wasn't just a matter of a simple cost or inconvenience like a tax, but it's something that's permanent, which is like a zoning restriction. And it was a fundamental part of the deal to have the floor space ratio at a higher, way higher amount from 3.22 to 0.3. And that was declared, and this is a case that was appealed to the BC Court of Appeals by the defendant in that case, which is Safeway, and they lost. So that's an example of that. There's other examples, and if anybody wanted to have a situation that they wondered if it fits into that category or not, but then I'd be happy to answer those questions at the end. Okay. Now I want to next go to some specific examples. These are actual things that are happening actually in real time with my office, in which I've been dealing with on behalf of realtors and selling clients as well as buying clients. Now, in one situation, I had a client who was a seller of a property. And then they gave the 2 months notice, which is legal notice for the buyer to have a vacant possession. Sometime in March, the ban on evictions happened. So they were, the tenants and the new buyer were starting to negotiate of a new fixed term tenancy so they can at least control the amount of time the tenant could stay. Then the ban came, and then the tenant says, hey, I don't know if I can find another place during this time. B, I'm afraid that if I leave this place, I can't find another. So then the buyer says, hey, I need vacant possession. This is in the contract. It's a technical breach. It will be a breach on the day of completion that the seller cannot give vacant possession. We can talk about the notion or the concept of frustration of contract at some point, but this is just specifically now dealing with this situation. How can we deal with it in a time of COVID? So a couple of things to note. The residential tenancy board is still open, or applications can be made for rulings before the board. In this situation, the buyer and the seller, myself, and with the counsel for the buyers, were able to negotiate ways in which to deal with it. But in the meantime, one of the things that I told the clients is that you can apply for an order of possession during the time in which this ban happens. And what you should be asking for when you appeal, and I haven't seen any residential tenancy board decisions dealing with this issue, but if and when it does come, you have to put straight forward in front of the board member all the cost related to the idea that the tenant can't leave. You can have the, and I can talk about the consequences of something, of what the things that can be claimed or not claimed later on. But I wanted to take this example just to say that until May 16th, orders of possessions, ban on evictions is in place. They may renew it on May 16th and may continue it. It's right around the corner. So that this is something that can be done. If you do go and you do have a situation where you're going before the tenancy board during this time, a tenant says, hey, I don't want to leave. I'm going to fight the notice of eviction, that even though it's legal, because the ban on evictions is for any reason. So it doesn't matter if you give the legal notice. It doesn't matter if you've got it before the ban occurred. When you do appear, you got to show front and center to the board member the cost. For the buyers, if they have to rent a place before they buy, the difference in the price, in which if the buyer refuses to buy, and all the legal costs involved in trying to negotiate something to deal with this situation. One of the things that I suggested and which can be done is ask for an order of possession to take effect as soon as the ban is lifted, whenever that happens. In any event, these are all things that undecided yet so far, and whether a board member at the tribunal would be willing to go that far, or give a time frame like 2 weeks after the ban has been lifted, and then to allow the notice to have effect. Anyways, next slide. One of the other questions that's come up, unfortunately, and I feel, regardless of how unfortunate the situation can be, the contract is still there. It is still binding. Even if someone passes away, a buyer or seller, if the buyer or seller becomes incapacitated and in the hospital under quarantine just returned from another country, the contract is still binding. So that's why I want to go to the next slide.
So Ivan, sorry, we got a question. Someone texted through. What happened with the buyer when he passes away? Then nobody can sign the contract and the financing. How does that work?
Oh, that's coming up.
Okay,
No,
thank you.
Next slide. One of the first things I want to say is that in that little small, tiny little font of your contracts, I don't know if anybody took a magnifying glass and looked at paragraph 17. But if you did, you see the word 17 plural in this contract. Any reference to a party includes that party's heirs, executors, administrators, successors, and assigns. Singular includes plural and masculine includes feminine. I blew out here just so that you can actually see. I'm getting old and it's hard for me to see, but there it is, right there. It's binding on the heirs, executors, administrators, successors, and assigns. And I just want to take this point to say, well, what's the difference between the heirs, executors, administrators, successors, and assigns? So, and heirs are the beneficiaries of the person who passed away. Executors are, if they have a will, then they appoint someone to manage their estate and to distribute their estate. They're called executors. If a person doesn't have a will, then they follow under a different kind of a terminology, but they're called administrators, not executors. Successors are like people who inherit, or people who take over the place of someone else if there's a legal mechanism for that. It does not have to be a will. And the last thing, the word is assign. So if someone had already assigned their rights to someone else prior to them passing away, or have the powers given to someone, if they're still alive, then the contract is still binding on those people. On the note of the assigns part, like one of the common things that happens is bankruptcy. You know, you hear that a lot of talk right now about the effect of COVID. There's going to be a lot more bankruptcies. The process of bankruptcy is a situation where when someone applies, the whole assets of the creditor who applies, the debtor who applies, is assigned to a bankruptcy trustee. And then the bankruptcy trustee office now takes over all their assets and has powers to deal with it, to deal with creditors, to sell assets. And so when we talk about assigns, the contract is still binding to any assigns, meaning it continues through so that the bankruptcy trustee will still have to deal with these contracts as a legal liability. Okay. Now the question that someone had asked, sorry, who was it that asked by text, Howard?
His name is Phil Guston. He
Okay,
said,
so,
yeah.
One of the first points I want to point out, and this goes to the next slide as well, is that in all these situations, and tell me if this slide is up there. I can't tell from my screen.
Yeah, it's
so
up.
that even the situation is not a frustration of the contract. Sorry, I have, and one of the things I want to distinguish between real estate contracts and other types of contracts is that personal service contracts, like one person has been hired to do one thing and that person passes away, the contract can be frustrated because that person is the person who's going to provide those services and it becomes impossible to complete. But real estate doesn't involve that. The financial obligations and the foundations of a real estate contract, a typical normal one, still continues to exist. The property, the townhouse, the home, the warehouse, the commercial estate, the property still exists. And that's the thing, you know, unfortunately, when it comes to this, it seems it's so drastic, it just shuts everybody down. But it's unparalleled in terms of how the law has naturally treated other things, physical events, physical unforeseen events, lightning, tornado, floods in Alberta, the fires that happened in Alberta in 4 years ago. These are physical phenomena which have not been equated with this widespread effect of a pandemic. Even if it's because nothing happens technically, physically to the properties that are being sold. Okay, so and that continues even if after one of the deaths of the parties, buyer or seller, happens. Now the question that was just asked, like one of the, I want to maybe, let me see, because I think I talk about it somewhere else. Let me see if there's a slide that talks about it. You know, when we get there, we'll get there and we'll pass through, but this is a very good question and I want to keep it in forefront while we're talking about it. There's two situations if someone passes away. They either have a will or they don't have a will. And that's the two distinct things. So one of the first questions is, the person, the buyer or the seller, do they have a will? Secondly, in the will itself, who do they appoint as the executor? In the will, if it points out someone as the executor, that is a valid appointment in a sense that there is a legal document called a will. Sorry, Howard, it's not on the next slide. I'm just going to go without.
Okay, sorry. Okay.
The question is important, but it's like
Okay.
I think 7 or 8 different slides down. But since we're on that topic, I might as well address it.
No worry. Sorry.
Yeah. No, sorry, you guys don't have a slide, but I'll just go through this whole thought process. The idea is that the will is a valid document unless proven not to be valid. Now, the probate process, people are wondering, hey, why is it necessary? Well, probate is necessary for land title office. It's very important for any land title office documents to be signed to someone who has been given the legal power and proven to be given that legal power. So any transfers or mortgages will not be able to be filed if someone who is appointed as the executor under a will, but that will has not yet been probated to actually sign those types of documents. But the question is, the executor appointed under the will has the power. It's just that it hasn't been challenged or disproven. So the executor who finds the will then says, hey, I have to find a lawyer, I have to find a notary, I have to start doing the steps that are involved as an executor. And quite often when it comes, and I do probates and I do administrations as well, so I know this as well, is that the executor comes, family member comes with a copy of the will. The copy says that the person who comes to see me is an executor. I take their instructions and we can sign a retainer agreement. I am following through and listening and having a contractual contract with this executor of the estate to help them probate. But that doesn't mean that they don't have the authority. The probate is a process to prove that the will is a valid and legal binding will. But in the sense that the question is, it's proven to be valid. It's proven, but there is still the idea that it's still the will itself is a contract. Is a legal document, and it confers legal powers. Whether someone accepts it or is it subject to challenge is a whole nother issue. The problem, so that the person passes away, if they have a will, you find the will, you know the person who stands in place of an executor. It could be 2 people, it could be 1, it could be the first person, it could be several contingent executors. Then you have to see if they have the power, you identify them, and they have to step up in order to be the representative of the estate. The issue is land title office. They won't accept the document if it's not been probated. But so that situation that I'm actually right in the middle of it right now is to deal with the fact that it's not yet closed. There's still a couple of weeks to close. The buyer is looking for a lawyer, and the buyer then the buyer's family is looking for a lawyer. So then I have to start negotiating with the lawyer to see, is there a will? Does the will exist? Have they appointed an executor under the will? Does that person who's been appointed is around, is in BC, is capable of performing and acting on behalf of the estate? B, if they're not in the province, if they're incapable, if they already passed away, then is there a contingent one? Is there a second alternate executor in the will? Then we start looking, and once we find, and then there's a whole bunch of issues dealing with how do we have a binding contract with an executor who has not yet been proven by court, been appointed by probate, but you still have a binding contract. So we're working that out. So the first question is, there is legal authority. It's just not proven to be unproven yet, to be not legal, okay, and not valid. The other problem is, what if the person doesn't have a will? And that is key, because if there's no will, someone has to actually approach the court to make an application to become the person who is the legal authority on behalf of the estate. And in the absence of a will, it's up to, there's some natural categories of people that can apply, such as a spouse or the children or the parent. But these the applications will actually have to be made to court to get that appointment. These types of applications can be done by affidavits. The courthouse is still open for filings. So you need default orders. You need orders that are done through affidavit materials. That information can still be received by the courts. They don't have hearings, so because if there's a contested application, then it won't be heard. But applications to get the administration or powers and through the courts can still be done. So, but the process right now through probates in the states can take anywhere up to 6, 7, 8 months or so. So in a situation where a buyer or seller had passed away and they found reasonable efforts and to locate a will is unsuccessful. One other thing too, if nobody knows where a will is done or not, or where it's kept, the Vital Statistics Office in BC, you can do a wills notice search. You give the name and birth date of the person and the aliases, and then in about 2 weeks' time, you can do you get results of a search to see whether or not that person actually had a will, and secondly, where it's kept. So if anyone comes to these kind of situations and needs steps and guidelines about what to do and where to do it, you can contact me as well. So before in the beginning when I talked about real estate, there's all situations about real estate that I've been involved with involving not just buying or selling, but the transfers of properties through probates and administrations in court, as well as foreclosures as well. So there's many different ways in which real estate can be dealt with in the courts in a legal way. And I've done practically all of them. So anyways, so I think that's the question that a long way of answering that question. So maybe we can move to the next slide, Howard.
Okay.
So we did what to do. Practical things about what to do, and you start negotiating. You can't do a transfer if you are the seller who passed away. You just can't, because Lantau won't accept it. But what can you do? You're in a technical breach. You cannot have the document signed. The buyer says we're ready, willing, and able. We've prepared all the documents that the buyer had signed. Then there could be a breach. So what can you do? If the buyer really wants the property, if the estate of the family really wants to sell, you can negotiate an extension of time. You can also assign the contract if you're a buyer. The buyers, which is one of the things that I'll be reaching out to that situation that occurred, is if the family through the executor can assign or sell if they don't want to complete. Do they have another party they want to take over? And we can dot our I's and cross our T's and do an assignment contract and take care of all the notice of assignment issues so that the real estate contract can be assigned to new buyers. I haven't checked the registries to see how long a probate process can be. And prior to COVID happening, it was taking about maybe 3 months to 6 months sometimes. The other situation is if there's a deposit and whether or not, because the completion can happen, there's a negotiation of the terms of how to release the deposit to the seller if they don't want to complete. So these are all issues that come in. I went on length just earlier to deal with who has the last point there. If there's no will, then there's no one who has legal authority to act for the buyer. So anyway, that's a way of dealing with this kind of an issue. And trust me, this doesn't happen very often, and it's hard to get authorities, but practically speaking, you've just got to know what the rights are, know what the consequences are, and negotiate on that basis. If you go to the next slide, some of the things about the timing, you can just, if you really want the property as a buyer, you agree to wait till the probate happens. You can wait till maybe the administration of the estate happens. Then there's legal powers, and then documents can be filed at the land title office. Sometimes in this time and age where time is really important, you see that phrase on the contracts, time is of the essence. Sometimes people can't wait that long, but you have to see what are the circumstances. Would you rather that the deal collapse or arrange a time, maybe an extension of a short period of time to see whether or not the probate can happen earlier? Because of all the cases, trials, chambers applications in court that are postponed, sometime in May, they start having canceled hearings and courts reassigned to different dates, maybe there's a chance that, that these probate applications that are done by filing and paper only are quicker. And then you have to negotiate damages, losses between the two parties. Okay, next slide. Another situation that's more common than someone, either party passing away, is financing. So some of the practical things to think about is extensions of time to complete. If you're the seller, consider an agreement to release the deposit. You have realtors, all of you realtors out there, hey, you know, I did all this work, what's going to happen? Negotiate in the terms of any kind of a deal to release of the deposits at the real estate offices so that the agent can be paid regardless. And it's not just a matter of damages between the buyer or seller in some situations, but all the work that you hardworking realtors out there have been put into it, and just to have financing stall and stop all your work from not being remunerated because of the work that you do. So in the event that there's any negotiations between the you know, the parties, these are things to think about. The fourth point over there is on behalf of a seller. You don't, if the buyer is you know, it's not, we're not placing blame in the sense that it's beyond the control of the buyer. If, for example, they lost their job, it's not their fault that their bank is just taking more precautions. And then even after subjects have been removed, subject to financing, they got their approval, it's not their fault. But so that is still a breach no matter what. So we have to think about compensation to the seller for, that's not their fault either. So you negotiate. One of the things to think about is the interest that the seller has to cover until the time upon which a new financing can be obtained. Having the adjustment date stay the same, so the seller's portion of the property tax and maintenance fees and insurance, etc., can be covered during the time if you do extend to a new time in which you can try and help the buyer try to get financing. And some of the things that are not contemplated too big is that it takes a lot of thought into the consequences for the buyer and sellers to come to an agreement, and quite often involves and requires a lawyer to look at the legal consequences both on behalf of the buyer and the seller. And so that you want to make sure that you negotiate in those things the coverage for the fees of either the buyer or seller if you're negotiating. In this situation, it's dealing with the seller, so make sure that it's not the seller's reasons, it's not even the seller's financing. It's not, so compensate the seller for having to negotiate that. One of the issues that do come up, and this is the last point, is that if there's claims on a deposit, there's a warning here. There's an act in BC called the Law and Equity Act, which has sections and paragraphs and provisions that deal with relief from forfeiture, which is the amount of the deposit. If the amount of the deposit is so excessive, it can be considered a penalty. And if it is considered a penalty, and basically they look at the test whether it's grossly out of proportion compared to the loss suffered by the seller, the claim for a deposit may not be fully allowed, and only a portion of the deposit can be given or ordered. So that's a warning, just in case. And some of the things that has happened were if the financing didn't come through and there was plenty of time prior to completion, there could be arrangements for increasing of deposits gradually or substantially, so that if by the time that the completion date happens and financing still doesn't come through, that the amount of deposit can be so high, and then that the normal rules of forfeiting the deposit if the buyer breaches may not be applicable anyways, and not the entirety of the commission, the deposit can be claimed. Okay, just a warning there. I go to the next. Oh, thanks, Howard. That's pretty cool. You can actually do that. Anyway, thanks, Howard. Now to the next step. Now, if your buyer and your financing falls through, you're not in as much of a good, how would you say, negotiating position. You don't have a lot of bargaining power. There's concepts some people have talked about. What if I walked away? The problems, and I want to point out the problems as much, is try as hard as you can, as much as you can, in whatever creative way you can find to not do that, because you're not only risk the deposit, but you may have to risk the legal fees of the seller. You might have to risk any differences between if the seller eventually sells for a different price that's lower than what you contracted for, and they can sue you for the difference. This is like months, years later, 2 years later, after the deal had collapsed. You can be liable for all of that even afterwards. So try as you can to consider a time to complete. Look for different alternate financing. Look for other partners to invest with you. One of the things that I would highly advise people who are able to find people who can partner up and front some cash towards purchase is to sign something called a bare trust agreement. You might not have heard that before. You might have heard it, but not sure what it means. But basically, it's a mechanism which allows for the registered and legal title of a property to be differentiated from someone who actually has something called beneficial ownership, so that someone can own a property but not be legally registered. So bare trust agreements is one mechanism which allows for that to happen. Another way to do this is to consider private lenders who are willing to do a private mortgage on title, not your traditional fund way, not through the chartered banks. There's many ways to do this. If you have somebody who's willing to front the money directly to you, it's a personal relationship. You might want to consider a private loan agreement registered on title, different terms. In that situation, I have many different clients of mine who are able to find family members, parents, brothers, sisters, aunts and uncles, nieces. And so we negotiate and we draft up an agreement to put terms different than a chartered bank, I must say, with maybe interest provisions, maybe or maybe not provisions dealing with enforcement to be registered. But do what you can to find it so that you can complete. You might have heard, and I don't have the case reference in front of me, but about a year and a half, almost 2 years now, a developer had actually sued a purchaser of a pre-sale who backed out, didn't complete, and they were successful in court. And we'll talk about other things too, such as duty to mitigate, but I just want to point that out. The risk is there. So do whatever you can as a buyer to complete and find someone to help with the purchase if you can. So go to the next slide. Vacant possession. We dealt with that earlier, dealing with my client, some client situations where you don't have, aren't able to, not the fault of either the buyer or seller, the tenant would move out. But think about as a buyer, think about the buyer's cost for not being able to get vacant possession. They may have moving or storage or rent costs. They may have a pre-approved mortgage which expires by the completion date. They may have a difference and they can't borrow as much, or whatever they borrow will be more costly later on. And then there's loss of expectation value, which is if you actually completed what's the difference between the value at that time versus the contract price. These are all different things that a buyer can claim for as compensation if the seller is unable to deliver vacant possession. In any event, regardless, all of these things are subject to evidence and proving in court of what the losses are. So the best thing to do is hire a lawyer to negotiate with you, both on behalf of the buyer and seller, to deal with the issues, come to an agreement, rather than letting it all fall and subject yourself to court litigation. There are cases that support one and cases support the other, and court ultimately is very unpredictable. So if at all possible, avoid it, try to find a way to deal with it and negotiate. So the next slide, we dealt with earlier about someone passing away, but what about incapacity? Person's under quarantine, self-isolation. They recently returned from overseas. So in the last 2 months, I've actually had to deal with every single one of these ways that is listed here. So you might want to see if the person who's the buyer or seller, if they have a power of attorney. Is it in the name of the person who is on title? Does it match? Is it valid? Is it done in BC? Is it a valid power of attorney that allows that power of attorney to be registered at the land title office which then gives the ability of the person, the attorney, to sign on behalf of the person who's incapacitated, under quarantine, under self-isolation, not willing to come out, just recently returned from overseas. Nobody wants to see that person. So then you have that person who can be signing on behalf of that person. Second thing is called an affidavit of execution. I dealt with that with a couple of situations. Some of you realtors, you have long-time clients. You buy and sell. You've known them for years. You're distinctly familiar with their signature on the documents, on the contracts, on their subject removal forms. You name it, you've seen it, you've done it. You've met their family, you've done their fin tracks, you've got their IDs, you know who they are. Now, it's not that you don't sign for them, but what you say or what you sign in front of the lawyer is an affidavit of execution. So I'll tell you how that happens. So I would forward the documents to my clients. In the last little 2 months, what I do is I set up a video interview, and so I can visually see the client through Zoom, through WhatsApp, through WeChat, through Line as well. I've done them all. And I actually see them signing their documents, their Form A's, their Form B's, their mortgage, their PTT forms, their Dutch statutory declarations. The documents, I physically see the person in the video. They show me their IDs. I compare their IDs to the picture on the video. They email and scan all of those documents they signed to me and to the person who's going to confirm that they recognize their signature. That person, and in some situations, it is the realtor. In some situations, it's a family member, it's a friend. They come to my office. They're able to come to see me. They're in front of me. They sign the form called the Affidavit of Execution. They swear that they are familiar with that signature. They're comfortable and they know that person, and then confirm that it's their signature, and they swear that in front of me. And then the documents are filed at the land title office, and that affidavit has been used traditionally in the past for people overseas, and they're unable to find a BC registered lawyer and notary. They can't find a lawyer who is authorized to take oath in BC, which is the test for land title office to accept officer signatures. And traditionally has been used for overseas, but has been allowed and amended to allow for this situation under COVID. Number 3, execution by counterparts. And so this is a way to facilitate the execution of documents without the transfer of the same document back and forth between the lawyer or notary and the buyer or seller. So if you have a Form A transfer, the Form A transfer is maybe handed out or printed or emailed to the buyer or seller. They print it out. Now they just have to be visually in front of myself. And trust me, when I thought of all the creative ways in which the lawyers in BC have been dealing with situations, it's very interesting. I've had them all. I've heard them all. And I've done them too. So for example, I've had some clients I meet up in our cars in a superstore parking lot. I see them, they pull up their forms. I look through the windows, they sign it. They're visually in front of me, but they have it in their hands because I emailed it to them. They printed it out. We meet, I see them sign, they sign their part, I sign my part. And then later on, they scan their documents, they email to me, I combine it with mine, and that is considered a one complete document, like a Form A transfer. Even one has a signature of the transferor, the other one has a signature, other page has a signature of the witness. We put it together, we file it in land title office, and that is accepted as well. The last part is just recently came out in probably 2 weeks, but and it's quite complicated and it's time consuming, and it has to do with a lot of documents back and forth being initialed, pass forth, confirmation of identification on the video, and it's quite extensive and complicated, and it probably take me another hour or 2 hours to explain. And I generally traditionally do not try to do that if I can do the other 3. So anyways, so just to highlight the point earlier about a frustration issues, it is not a frustration, because if there's a will, there's a way, and there's many ways in which to do it. I dealt with a lawyer who put the table in front of their house, put all the documents in there with the pen. The clients come and sign. The lawyer is looking at them from inside the house. watching them sign. They leave, they jump in their cars, the documents are sitting there, the lawyer takes it, and then signs their part by affidavit. If it's like a day later, when 24 hours after paper has lost its contamination, outdoors, it's in the sun. It's nice weather now, so maybe that may be more the recent news saying that the sun can break down the virus here. So maybe and then you collate and gather all the documents and then file. Anyways, many different ways out there. I've done a lot of them. Anyways, next slide, Howard. So earlier we mentioned something about specific performance and, as a term. And what is that? If there's a potential deal that may collapse, one of the things that the buyer may want is, I want to force the seller to sell that property to me. You file a lawsuit, you put a lien on the property, and what you're asking for is not compensation and money, but to force the sale to happen. One of the things I want to point out is, if you ask for specific performance as the buyer, it's rarely ever ordered. Mainly reason is, when it comes to real estate, that piece of real estate has to be so unique that there's no other substitute before the buyer can be successful in compelling a seller to sell. So, damages is the more regular or normal provable route to take in that situation. One of the things that to think about is a condo in a tower. Can you find other condos of a similar square footage with a patio? It's very hard to prove that it's so unique to the buyer that nothing else can compare and nothing else can be bought in lieu of that particular property. So specific performance, sometimes you can hear it. Can I order it? Can I compel the seller to sell? I just want to point that out. And there's a lot of cases to deal with how unique can a property has to be in order to be successful. We can always have a chat about that some other day. Next one. Thinking about the seller though. So can the seller compel a buyer to compel them to buy? That is also rarely the best option because there's these opportunities that could be lost during that time frame. Opportunities to remarket the property, to see if you can resell instead of that particular thing. The only reason why, maybe because of price, you cannot get the price anywhere else. But the idea is that if you can't, you're holding up the property. While you're trying to sell, you can still try to sue them for damages. Any difference between the eventual sale price and the contract price that was lost because the deal collapsed. And so and that's the thing. There could be other opportunities. There's also something which I'll mention a little bit further later on, or maybe at the next slide, is the duty to mitigate. So that's the next slide. In any kind of matters when it comes to litigation, the parties that are suffering a loss has to prove or show that they took steps and reasonable steps to mitigate their loss. And if no steps are taken, the defendant, the other party, can point to this as a way to reduce the compensation that would have otherwise been awarded. An example that I will point out there is buyer financing collapses, the deal collapses, seller sues the buyer and claims the deposit, but wants more, then later accepts a lower price and sues for the difference. But the difference is usually paid by the buyer as damages, but during that time frame, a higher offer had come about, and the seller did not accept, or the seller did not remarket the property and could have had a higher price rather than the price that they actually sold it for. These are all different things that, if I was representing the defendant, would try to point at so that you can challenge the amount that's being claimed. The seller would then have to explain why it didn't try to market it, didn't accept the higher offer, and didn't try to take steps to reduce the loss that would have been payable to the buyer. And so this duty is a theme, and any claim of compensation would have to face this duty to mitigate. So the next slide, I just want to turn over to some specific issues that happens in commercial real estate. All you realtors out there, I'm sure many of you deal with real estate commercial as well. But something that's common, or not common, but at least found in commercial real estate contracts and not common at all in residential, is the clause, there's a force majeure clause. And what is the concept? So I just want to talk about it. These are usually terms and paragraphs, contractual terms inside a contract. And they deal with situations such as what we're in right now, such as the pandemic. So the major components, an unplanned, not reasonably foreseen event. But one of the things as well about having these clauses inside contracts is that they normally do not allow parties to just terminate the contract. But instead, what it does is relieves the operation of the contract for a specific period of time. And that period of time is measurable, usually distinct and objective. So not based on, like, for example, if the weather clears, if the weather gets better, it's not subjective, it's very specific. And it relates to specific perils, and they cover it, usually called acts of God: earthquake, landslide, tempest, tornado, lightning, flood, fire. And quite often, this is where you actually see the actual coverage of the word, with using the word pandemic in force majeure clauses in real estate commercial contracts such as leases or even purchases. I just want to show you an example of one. So it covers all the different components that I just mentioned. If either party, despite their best efforts, and I read it out because I like to emphasize some of the points, is delayed from completing the transaction due to acts of God: landslide, flood, tempest, washout, fire, lightning, disaster, earthquake, storm, epidemic, pandemic, quarantine, or civil disturbance, an event within a 25-kilometer radius. So you cover not just physical events, but pandemics, which can be both physical but also can be very limited in terms of geographical scope. That the affected party solicitor shall provide a notice, the force majeure notice, to the other party solicitor a record of such event. There's a time frame, no more than 3 business days prior to the completion date, or no later than noon on the completion date. And this is an example, but I don't say that I recommend it, because I wouldn't want to have up until the completion date of noontime to give that notice. But you may be holding your breath and waiting for things to get better, and you want to continue until that point. Upon receipt of this notice, and it's not a discretion to choose to accept or not, the completion, possession, adjustment dates shall be extended for one time to the first business days, which occurs 30 days following the notice. And then the important terms for all realtors know out there to re-emphasize: time shall remain of the essence. The parties are advised to seek legal advice regarding how this clause may affect any related transactions that are closing on the original completion date. Because you may have to think about it, like, will the financing still occur if we move 30 days later? Will the subject terms that you had listed still be applicable 30 days later? So you have to think about all these things. Is the rental contract that you have with your tenant still effective 30 days later? Anyways, things to think about. Now I want to show you a sample clause found in a development contract. And I won't name which developer, but it's there. I pulled it out of their contract of purchase and sales. And things about developments is that they do have language that allows them to extend and keep on extending till an outside closing date. But they also usually have a section dealing with what happens in such situations as force majeure clauses, but normally and regularly they extend the applicable perils. So it's not just acts of God, it's not just these physical things such as landslide, epidemics, but it's other things such as, and in this situation it shows you line 3, and I just want to point out labor disputes, unusual geotechnical conditions, climatic conditions, inability to obtain labor and materials. These are all different things that are normally added, so that it's not just a pandemic, but allows for these other things that beyond the control of the developer to extend. And they consider this part and parcel of acts of God. So, and quite often in development contracts, the range of perils, range of events that are considered to be beyond the control of and unforeseen is extended and expanded as well. That's the reason why I want to point this clause out, so you can have a look at it. This is taken directly from a contract, a development contract. One of the things I want to point out is the very last line too. So, the vendor shall have no further liabilities, including costs, expenses incurred by the purchaser obtaining alternate premises. So they make it very, very contractually reducing their losses. So Other things to think about. We're getting close to the present exchange end, but I just things that have come across and that I had to deal with on behalf of commercial clients. I have clients that are saying, hey, I have insurance, maybe it covers pandemic. So they have business interruption insurance. This is the next slide that's on right now. Maybe I have rent loss insurance, or maybe I have a guaranteed rent insurance agreement, or contingent business interruption insurance. And then, oh, I think I heard something and it just came out, but the details are not fulfilled yet, or not completely detailed yet. The Canada Emergency Commercial Rent Assistance. So I just want to go through a little bit about each of these and what they are, and whether or not something can be found to help your client. If you have a landlord client, if you have a tenant client who run their own business. So the next slide, I just want to touch some points. Now, business interruption insurance, unfortunately, 90%, 99% usually doesn't cover pandemics. Insurance for business interruption generally covers physical things and limits it to physical things such as earthquakes and fire and things like that, that causes visible damage, physical and visible damage. An argument can be made that, if someone had was found in a premises to have been infected, whether or not the premises having the virus can be a physical defect that can be covered and can be an argument made, but generally it's not been tested and generally have not been proven successful if it's not something physical or visible. Now, rent loss insurance, sometimes these exist, you can cover the rent, but again, it's normally covered, covers perils that are covered under business interruption insurance. So it's again, normally just physical damage that's caused that can be seen, that they cannot operate your business and cannot collect rent and run as a result. There's other programs, not programs, but mechanisms. Sometimes there's property management companies, well, insurance that does this, but also property management companies that guarantees a rent. And these are two different things to a landlord. Some of the things that you have to watch out for is that normally for insurance purposes, they would test and look at the credit worthiness of the tenant in order to allow for that type of insurance to be given. So, and who knows in terms of in this day and age, whether or not a lot of the people who are losing their jobs can even be, prior to this time, be qualified. These things exist going forward, like a lot of the problems that are happening now. Nobody would have predicted this. It's unforeseen. Nobody would have seen this happen. But these are things to look at. These products out there, they do exist. They're crazy expensive. If you want to cover a risk for pandemics, they can be found. And there are options out there, but whether or not it can be tested to be proven, and you pay your deductible and things will work out, and don't know yet. Still to be proven. Okay. One other last thing is something called contingent business interruption insurance. I want to touch on that a bit, because if you are a business and you rely on that supplier, and that supplier goes out of business, or that supplier is affected by COVID, then this may be a way to get insurance coverage, because you rely on it. Say you're a cheese producer and you rely on the milk, and the milk farm got a ban on closures because of COVID. All of a sudden, you're not saying COVID is affecting your own business, but because of the business of someone else, and you rely on that business. So these are types of insurance programs that are available and that may be applicable in this situation. Because it's not a physical act of God, such as earthquake or fire or tornado. It's a business that you rely upon. You can't do your business until that business does their business. The last thing I want to point out, and this is my last slide before we can open up to some questions during this presentation, is the Canada Emergency Commercial Rent Assistance Program that the federal government. And I just want to touch a little bit about it, because it's basically not free for everybody. It's actually that the landlord at the end of the day covers 25% of the rent or swallows the loss. So what happens is a one-time forgivable loan. It covers 50% of the rent payable by the tenant for a 3-month period of time. But the loan is forgiven if the landlord in turn reduces the tenant's rent by 75%. The tenant in turn only pays 25, not 75, and saves on the 75% of the rent. But then that means if you do the math, the landlord then is left footing 25% of the rent. The reason why some of these is important is that it is just temporary. It's to allow the businesses to continue still. It allows the landlord to still have a tenant instead of having collapsing deals and no tenants at the end of this pandemic. You have a tenant, you're trying to help. And ultimately, and I have all these clients of mine that are landlords that are, I tell them, look, it's trying to find a way in which you can help everybody. It's nobody's fault. You cover some of your expenses. You try to help the tenant, keep them running. They can apply for, the businesses can apply for other benefits such as wage benefits. But we're all trying to help each other out. So I generally want to try to get my landlord tenants to recognize that situation, and vice versa. When I represent a tenant, I point out the potential loss that a landlord could face with an empty place at the end of this, end of this challenging time. If we're out of it soon, hopefully we are out of it. So, anyways, to the next slide then. So I just want to point out if some of these cases and references to the laws, and particularly that clauses on COVID, such as force majeure clauses and cases, is available. The PDF that I forwarded to Howard and Herb, they don't have links. The Word documents can contain through email hyperlinks to different resources. You guys want to call me, call my cell. I have my cell number on the front of this last page here. I'm available quite generally. The realtors out there that know me, and a lot of you I see some familiar faces out there today, which is great. A lot that I haven't worked with, but I'm looking forward to working with you. So you can text me with situations, and I'm quite accessible in terms of helping with a situation if you need to tell you one thing and not like and then move on. So, but don't give this number maybe to the clients. Sorry. So this is just for you guys. If you're out there, you can access or talk to me, deal with a case that you can help. And it doesn't matter if the deal is actually coming to me or not. I quite like to help as much as I can, including like one of the things personally about me is that I remember when I was in law school, I really wanted to go to teach. I was thinking of doing my master's and doing PhD and teaching because I love teaching. So this is like a nice little format that allows me to introduce ideas and then reach out and help you guys do your job. And hopefully when things get better out there too, and and Howard was saying that the market is getting better. Yeah, go out there and practice and do your job safely. If you have any questions and you have lingering issues such as the ones that I've talked about today, feel free to reach out to me. Howard can also talk to you about later, or Herb and any of your managing brokers, if you want to practice out there using your personal real estate corporation, and then we can help you with that. So thank you, everybody.
Ivan, thank you. It was a great presentation, very informative. We have quite a few questions here. Are you okay to answer some of the questions?
Oh yeah, for sure. Yeah, we got some.
Okay. Yeah, here's one is what security can a beneficial owner have in a bare trust situation?
The idea is that you actually have the bare trust agreement that has been signed by both parties. In the absence of bare trust agreement, what you may have is what he says or she says about who owns what. So that's why it's important to have a bare trust agreement that specifies the obligations, the percentage, the ownerships, the between who the legal beneficial owner is and the legal owner. So it's all written out there. If there, in terms of security and collateral, you can't really register it, but what you do have is a legally binding document. And so if you want to challenge it, it may be very hard to challenge why you sign something like that. A bare trust agreement would indicate not only reasons, a good one, would indicate not only the reasons for it. For example, if someone has the, it reminds me of a Pet Shop Boys song, whatever, you guys probably know, you guys are, that's my generation there, Pet Shop Boys. Somebody has the brawn, another one has the money. So one person has the money but doesn't have the credit, the other person has the credit but not the money. The person who has the credit can actually get the mortgage and can be registered but didn't have the down payment money. So then you put into an agreement that the person who does is not entitled but fronts the money is ownership of the home. So there are plenty of reasons. You could have a situation where it's a spouse situation, husband and wife, where the husband is a very litigious litigation, is in an occupation is highly litigious. So to protect the spouse from being opened, instead of having the husband's name on title, they can have the wife's name on title and have a bare trust agreement. This is separate and in addition to any family law rules out there, which I can help out as well. But but if you're just dealing with one issue, one property, you can do that. There's many different reasons. Bare trust agreements sometimes and quite often with parents, they're lending money to their kids to buy a property, but their kid they have a girlfriend that they don't really like that's been living, and it's not quite 2 years yet. In 2 years, it becomes common law, and there's an interest gained in that real estate. The parents, I'm lending 150, 200, sometimes $1 million to their kids. They don't want to have any of that. So they send a bare trust agreement that says with terms and conditions as to the percentage ownership. Even if the son or child is registered 100% on title, part of it belongs to the parent. If there was an eventual separation or breakup, the other spouse or the common law or has a claim, they can only claim the percentage that's not owned by the beneficial owner. So their limitation happens with the limitation of the potential risk. So those are different things that you can do with the bare trust agreement. Another thing that that can be considered, that can be a little bit more, how would you say, protective, more protection, is if you do a private loan. So you don't own the property, but you have a lien against the homeowner, like a private mortgage. When you're registered on title, then it prevents, say for example, and this is a risk from the question that was just asked to me. Sorry, who was asking that question?
Shafiq Rashid, yeah.
So Rashid, so the idea is that you don't register a bare trust agreement, but so that the owner who actually legally registered can sell the property without the trustee, the beneficial owner, actually knowing. You know, before they even know it, they turn around, it's already sold. You can try to trace the monies and still sue, but it may be hard because you don't have security held in your hand. So the idea that a private loan agreement maybe is stronger to protect against that. But then again, you know, when it comes to a bare trust agreement, quite often I say that you only do that with people you trust. Emphasize and underline the word trust in bare trust agreement. So private loan agreement, you register the mortgage on title. Nobody wants to buy a property with a mortgage registered. It's like a lien. So that's protecting against, and if you have people that you don't really know, you want to specify it more as a loan to be owed back, you can say what you want in terms of interest. No interest until requested. No interest until requested, and if interest starts into a certain rate, 3% starting from the demand, these are all different variations of a private loan that you can put. You know, on behalf of my clients that are parents, they put down, and in the case of my son separates from his spouse, that triggers the default event, not default, and the payment event. So payment starts to become due upon occurrence of a triggering event like that. And then interest starts occurring at 3% if it's not paid right away. And so these different things that can be done in a private loan if they're able to register it against title.
Okay, thank you. Well, that was a great answer, Ivan.
Yeah,
that's okay. We have another one. We have quite a few, but here's another one. A single house with commercial zoning is subject to foreign buyers tax?
Yeah, the foreign buyers tax is on any piece of real estate that's in which the buyer is not a Canadian citizen or permanent resident.
For commercial zoning, that will be applied as well.
Yeah, it's all property.
Okay, we got another one here. I'm trying to scroll up because everybody's texting in here, thanking you for a great presentation. If a child, Canadian or PR, buys property and funds by the parents or foreign entity under the bare trust agreement, do the child needs to pay foreign buyers tax? The child is a Canadian or PR.
Well, two things. On the two points I want to point out. When the property transfer tax form is being filled, it'll actually say, is the purchaser buying as on behalf of a trust, as a bare trust? And there's consequences if the person finds out later that they say that it's not, but it actually is. Does that make sense?
Okay.
So if they're saying that they're buying on behalf of the trust, then they have another section on the page that defines who is the settlers, who the then the residency and the residency of the beneficial owners, and then you're stuck. So technically, that is a way in which I think the office has already thought about to prevent that from happening. So in other words, likely yes.
Okay, another question is force majeure clause applicable to residential contract and purchase and sale?
The idea is that the question is it applicable? The idea is that it's a clause that's actually written into an agreement and agreed to. It is not something that just gets applied as a concept. So in the residential, and I did mention, I gave you some examples of a residential and purchase contract, but those are more found in commercial deals, not residential. But if you are doing one, you draft it up and you stick that in and both sides agree, then you have a force majeure clause that actually is in operation.
Okay.
You know, so it doesn't get applied, it gets agreed upon. So thank you.
Okay, and here's another one. If both seller and buyer agrees to collapse upon all subject removal, buyer's brokerage will release deposit to the seller. That's usually the case. The buyer's brokerage holds the deposit. What about commission payable to the buyer's agent or the seller's agent?
Yeah, you might want to, in that situation, make an agreement so that the release goes to both. Two ways, the buyer, the seller, you assign the right to authorize the release to the buyer or seller, or you have an agreement that deals with the release to both. So release of all commissions are paid, so everybody gets paid. But you want to make that, you want to specify it in the agreement if you do the collapsing deal.
Okay, I think that's all the questions so far.
Ivan,
Sorry.
Ivan, I'd like to, on that point, under the Act, we're not allowed to, nothing that we do may affect how we do business, including being paid. So if we wrote up something like that in order to secure the commissions while we're securing the deposit, we are in fact putting our interests in front of the seller, and we are breaking part of the regulations.
Yeah, I hear what you're saying, and one of the things that I would suggest is that it's the buyer, it's the actual buyer that's supposed to do that, not the agent. So the buyer has to do the instructing, the seller has to do the instructing and the directing, and so it's your clients that are directing you to do something. It is not you telling your client to allow you to do something. And normally in that situation of a collapsing deal, you're not going to negotiate an addendum to the contract. It should be done between the lawyers, and the lawyers would specify the parties, not the real estate agents, to do something, because you'll be acting on behalf of what your client tells you, and we'll be doing an agreement that tells the seller or the buyer to direct their agent to do something. Does that make sense?
Absolute. And on the other hand, I've never met a lawyer yet that have instructed their seller to pay a commission if they didn't have to.
Yeah, you know, the whole thing is whether parties agree, right? The buyer and seller. Like if the buyer wants to give something, wants to release something, and listens to reason, I was like, hey, look, these agents have been busting their ass off, excuse my language here, to get this, and then it's not their fault that something happens that causes the deal to collapse. Whether all these reasons that I had that mentioned during the time, give them some compensation for it, give them something, authorize it, prove it, and do what you need to do, sign what you need to sign in order to allow it to be done.
I've never met a nice lawyer, Ivan. You must be.
well, that's the thing. I think if you look at the bottom right-hand corner of my ad, and that little thing on my the last sheet there, professional courteous service.
Yeah.
Be nice to everybody. Be considerate.
Professional and courteous don't go together in an LLC.
Well, you know, maybe my next ad, which I say all I do is litigation, I'll take that off. But
Ivan, sorry, we got a few more questions. Here's one. two buyers register as tenant in common. One is a Canadian citizen and other isn't. If the non-Canadian citizen register as 1% ownership, would the foreigner buyer's tax be allocated on that ratio also?
Oh, yeah, for sure. Yeah, but the problem sometimes happen is that like any situation, when someone wants to avoid a certain tax, how do tax authorities question that arrangement? They look at, is that really 1%? And then you go, does that make sense? You can do it, you can be challenged, and if you're audited, then you have to provide proof that it really is. So one of the situations that happened in an example, not an example for the percentage point, but an example for in a residential situation where a person says, hey, I live in this house, I should be exempted from the GST because it's going to be a residential property. The government authorities, the federal government or the PTT office, they contact the BC Gas and 40S, hey, give me the receipts for the person during the year, and it doesn't change. And then therefore they said, hey, look, you're not residing there. We have evidence that shows otherwise. Now the burden shifts to the homeowner, the person claiming to the exemption, to prove that they really should be exempt. And until that time happens, there's a bill to pay, there's a fine for not disclosing the true intent or true reasons behind this particular arrangement. That's just to show an example of how it can be done. Now, they may ask for, well, if it's 1%, show me the money flow, show me the percentage of money, show me evidence in which the person who owns 99% actually owns. If they're taking instructions and directions from the 1% owner, hey, so-and-so, buy it for me. Hey, so-and-so, don't sell it to anyone else until I say so. And then you're looking at control and actual ownership and actual power versus just what's written down on paper. So anyways, that's my 2 cents in. You can try it, but it's risky because if that's the only way, and the only reason is because of trying to shave off that tax, that can be challenged.
Okay, we have another question here, Ivan. When one set of parents give their daughter a gift that is not to be repaid, you need to have a separate agreement with the daughter and husband, confirming it was a gift for the daughter only. Is that right?
Yeah. The question about that is not that it's not valid. It's just that you can be challenged. Okay, so that's a separate thing altogether. You can challenge it, but if you have that separate agreement, and quite often what I do in these situations, if you do a gift letter, you can even do a bare trust agreement. So you transfer it to a child. Maybe you give 50%, 30%, 60, 80. Maybe you keep some of it. You have a bare trust agreement that specifies if it's a different percentage ownership, or a gift letter if it's a gift. If it's a gift that is given outright, then it's a gift letter to confirm that it's meant to be a gift and not be considered something called because there's a principle also about adults giving something to adults. It's presumed to be a loan, an exchange, something that's meant to be giving something back. But if you give it to a child who's under 19, it's meant to be a gift. So there's presumptions operate in law. Of course, they can be rebutted, but yes. So you want to give a gift to a child, you want to supplement it with something written, a gift letter, or a trust agreement that really specifies the intention behind the transfer.
Okay, so I guess your comment is, to have a separate agreement to protect the daughter in case of the divorce. Then that would, be a loan to the daughter only.
Yeah, quite often, sometimes it's not just the spouses, but siblings, right? Like siblings who say, hey, well, why don't I get a piece? And you meant to give it to me, or et cetera, et cetera. So there's these other ways in which it can be challenged, and other parties who can challenge it. So you want to protect it, you do something separate.
Okay, so this was a hot topic before the COVID-19 came in with the strata insurance. So we have a question here is, if a buyer removes all the subjects and between subject removal and the completion date, the strata cannot renew the strata insurance. The buyer's bank will not fund the mortgage, and there's no strata insurance. So I mean, it's going to come up, which what does the recourse the seller has or the buyer has? Yeah,
so yeah, difficult times because consequences of no insurance and no financing. These are all things that can't be considered permanent or temporary. Is it permanent or is it temporary? Can you find one? Will the products arrive? Is it just a matter of expense? So first of all, frustration of the contract will probably not apply because it's not been proven to be impossible. It's just a matter of cost, and you have to find and look, and eventually you will find. So for me, in terms of what practical steps can be done, I don't have any answers to that other than practical realities are see for the buyer or seller, see where the chips fall and try to negotiate your way out of it. So really, but there is a technical breach on behalf of the buyer that can't get financing. The idea is that you have a property that's been certified by the home inspector to be, for the city, to be occupation certificates there. The legal descriptions are all there, the physical things there. It's just not insured. Is insurance such a fundamental part of a property that you can't buy without it? You can buy properties without insurance. You can. So it's just that you're not protected. So.
Okay, great. No, thank you, Ivan. I mean, it was very informative, and thank you for taking all the questions. We do have a few more, but I mean, I think we're out of time here. I think you need a little rest, but thank you very much.
Yeah.
And thank you.
You're very welcome. And guys, if you're out there, maybe when this whole when it's open up more, it'd be nice for us to actually meet in person. I've been to some of your offices. I think last year. I think I was at the Carousel office dealing with latent patent defects and with Wolfpack home inspections. Anyways, when this Zoom thing is interesting, but it doesn't quite meet what being in person. So I'll be looking forward to meeting all of you guys in person sometime soon. So.
Thank you very much, Ivan. Thank you, and all of you. Like I said, you have his contact information here, and anybody needs a copy of the PDF. I've sent it out to all the managers, so please ask your manager for a copy. If not, send me an email. I'll send you a copy myself. But like I said, thanks again, Ivan, for putting the slides together. We packed a lot of questions into those slides, and you must have spent hours doing this. But thanks again.
Yeah. No, you're very welcome. Thanks, guys.
Okay. Thank you.
Thank you.
So everybody, make sure you put your name, first name, last name, the V number, and which office you're from, so we can track whoever has attended the meeting. Yeah, thank you. Thanks, Ivan.
Great, thanks. Maybe after this meeting, Howard, you and I can have a chat. Talk to you soon.
Yeah.
Thanks,
Okay. Thank you.
Bye.